you go.
Hey, good morning, everyone. I'm Chris Parker. This is Kristen Ishihara with the Ishihara and Parker Law Firm here in Longview, Texas. And today's topic is basically, are you leaving a trick or a treat for your family when you pass away?
Holiday we're very clever.
That's right.
Yes. Mm-hmm.
Kristen, what are we talking about today besides our own jokes?
Well, yes, please enjoy that. So just talking about how to make sure that when you feel like you have your estate plan done, that it is truly done and there's not some hidden trick in there for your family that you've missed because maybe you tried to do it yourself, maybe you say you've had it done but you really haven't done it, or maybe you have used a lawyer who doesn't specialize in estate planning, and so somewhere along the way you've gotten some kind of hidden trick in there for your family. I'll tell you one, this is not going to be our number one on the list, but one that always gets me is, well, my attorney said this is the kind of will that doesn't need to be probated. That is an oxymoron. A will to transfer title has to be probated. So the underlying foundation of what that person thinks about how their estate plan works is incorrect. Yeah. So it really, really matters that you understand what the estate plan is, you understand how those things will go, so that you don't have that, whatever you've told your kids is coming or your spouse is coming, that you do actually have it set up the way that you think it's going to go. That happens so often in our office where a child says, well, mom says this is what was going to happen, or my husband said this is what's going to happen. It's just a failure sometimes to understand how your own estate plan works. Mm-hmm. So we just want to talk about some of those common misconceptions that you may have hiding in your plan. So number one.
Yeah, well, and so if you have a will, like you said, the presumption is you must probate it. Let someone tell you you don't have to. If there's a will, the presumption is it needs to be probated, which became our number one. Inside or below that, our number one, if you're looking inside the will and, mom and dad had 3 kids, but relationships were strained with the 3rd child, so mom or dad left that child $1. I don't think that's a great idea. You agree with me. We do not think this is a great idea. If your intent is to exclude someone, then you simply identify and name and remove, or I guess name and then don't include, but I prefer exclude specifically, but whatever. But don't leave them $1. Why do we not include token gifts?
Yes, we've had several videos on this, so you can find lots of other information on it. There is some misinformation out there that you have to give $1 or you have to give a nominal amount to someone that is a child. In Texas, you do not. There is no right of theirs to inherit. It is your stuff. You can leave it to whomever you want. And the problem with leaving someone $1 is your executor has a fiduciary obligation to notify any beneficiary under the will within 90 days. And if you have 3 kids, and if you've left one $1 and then split everything between the other 2 and asked one of those 2 to be the executor, they've now, by certified letter, got to notify their sibling, hey, buddy, you're getting $1 in mom and dad's will, when if we had just done it with a specifically disinherited that child, there would be no notification requirement to that child that you are trying to leave nothing to. You're not trying to be mean to them after your death. You're not trying to poke them. You're not trying to leave your kids with the obligation to reach out to that child and put them in a conflict. So the correct way to do that is not to leave somebody $1, but to specifically disinherit them.
Yep, absolutely. Absolutely. Okay, next thing we see often that is not correct is that we will have a will, and inside the will, they'll talk about who's in charge, the executor or executrix, and they don't make them independent, right? We love independent. It's very easy to be an independent executor versus being anything else.
Right.
What if our will lacks the magic language of an independent executor or executrix, able to operate without bond, all the powers associated under the code?
Sure. So this one happens a lot when you try and do your own will, because you just don't know that this is required under Texas law. You think, well, I can just write a will and say who gets stuff. Well, someone, the executor, will have to be the person that makes all those things happen. They have to take your will to probate in the local county court. They have to hire the lawyer. They then have to carry through on your wishes. So someone will be responsible for that. It does not magically happen when you write it down in a will. Something has to happen at your death. And that executor is going to need to be, ideally, named to be an independent executor, which means to act without court order every time they want to do something. So if you've not said that magic language in Texas, If they want to sell your house, they have to get court approval at 2 different times to sell the house. Then to make distributions to either creditors or beneficiaries, they have to get court approval. So the cost of your probate has gone up exponentially because that non-independent executor has to get court approval for everything. To change from being a dependent to being an independent requires consent of all the heirs, all the people listed as beneficiaries in your will, to allow that person to serve independently. A lot of times, this is not something easy to get because maybe someone is estranged, maybe someone is just disagreeable, maybe somebody is in jail. There's all sorts of reasons that it is difficult to get consent from other beneficiaries, and you have to operate as a dependent administrator, and it just not ideal.
Yep.
Anything you want to add?
Nope. That's where get it right.
Number 3, I'll let you do number 3. So number 3 is not having the will done with the correct validity, or if you've moved from out of state, not getting it reviewed. Why would that be a major mistake?
Yeah, you bet. So we have many folks in Texas who are not originally from here. So you moved to Texas.
Glad to
Yep,
have
that's
you.
right. You bring all your estate planning that you did in California, Illinois, Florida, New York, Kentucky, wherever it may be, and you come down here thinking that everything is good. And it is good in the state from which you came from. But that does not mean it meets the requirements, the formalities of Texas law. Texas has certain things that must be, depending on type of will we're dealing with, must be in that will. Is it a holographic will? Is it a tested will? Do we have 2 witnesses and a notary? Do we have the right language? Every state's a little bit different. Texas, if you are in Texas, I'll just say, if you have moved to Texas, if you are in Texas, you need to have Texas estate planning documents. Do not be relying upon your out-of-state documents. Double so if you're a blended family. But no matter what, anyone coming out of state who gets here needs to have their documents reviewed and most likely redone. It does no good if your will or power of attorneys represents Virginia code or Alaskan state law. You're in Texas. You need to have Texas documents. So I see a lot of people come and
even if they're valid,
yeah.
It does not help your children to argue with a bank or a medical doctor who does not recognize those forms.
Yep.
I mean, the point is to make it easier for those individuals that you're putting in charge. It is not to have an argument about, well, my Virginia form is legally correct. That may be true. That may be the legal answer, but it doesn't matter if people don't use it and don't acknowledge it.
Yeah, and it's, remember, they're only using these documents most likely at a time where you can't participate in the process. So these documents need to work. They need to be seamless. They need to be effective. And that's when you find out they are not, or you won't find out, your children will.
Right. Yes. Yeah. Not a fun surprise. So yes. Also keeping them up to date. So like when we talk about having the executor not listed as independent, that also applies if you've run out of executors. So like if I did my will right when I got married and I listed my spouse and then a sibling, and I never went back and updated it to be my adult children. Yeah. If I'm the last person surviving, well, now I have no listed executor at all, and someone has to apply to be the administrator, and all of those other things apply about being independent or dependent. If you have a correctly done will with correctly named executor, with correctly named beneficiaries, and our number 4 is that you have the original that makes it to the possession of your executor, then you can avoid notification to people that don't need it, extra steps, extra bumps along the way, just the bad things that can get in the way. If you have all those things done, then you can avoid that for the executor that you're leaving. But number 4 is that executor, to probate your will, needs to be able to present the original to the court as they're applying. That means they need the wet signature. Not a copy, but the original will that you signed needs to be kept somewhere safe that your executor can get when they need it.
And how many originals are there?
1.
Yeah, I've seen so many folks come in, brother and sister, each bring me mom and dad's original will. There's only one original. There should be only one original, and that needs to be protected until it's needed. Hopefully not for a long time.
Right. And you have to think a little bit about the people that will have access to it. So if you've named a third-party executor because you don't want it to be one of your kids, then don't leave the original will in the possession of your kids. If that original will never sees the light of day, it doesn't exist. So you have to give it some thought on how you're going to preserve it. Make sure the executor has access, that they know. that no one else has access. So I don't know what that means for you. Maybe it's a gun safe. Maybe it's letting your executor actually keep the original, depending upon what stage you are in life. For me, I want to have my original because I might want to change it later. So I want to be able to physically destroy it, and I don't want to have to ask for it back. But if I'm 89 years old and I'm pretty positive I'm not going to change it, maybe I give it to the executor and they get to keep it now. But so just having that conversation to make sure that your original is there, is in the hands of the right person. I've had several recently where the original was not in the correct hands and it was difficult simply to get it, and sometimes you cannot. Can you probate a copy of a will?
You can probate a copy of a will. We prefer not to probate a copy of a will. There's a presumption that if the original cannot be presented to the court, that it was destroyed with an intent to cancel. And your the executor, proposed executor has to overcome that presumption. They have to show why it was not destroyed, what happened, what was the reasoning by it, what's the good cause why the original cannot be produced. Is there a reason to believe that it was destroyed and no one was updated? I mean, it's a fact-finding process, which hopefully doesn't become an expensive process.
Right. And you have to notify anyone that would be an heir at law. So let's say that I have 3 kids and I'm leaving everything to one kid in my will. If that kid can't produce the original, we have to notify on their behalf the other 2 that would inherit if the will didn't exist. So you're just kind of poking people and suggesting that they come give you a hard time in court with that $1 bequest, with not having the original. You're just setting up a potential conflict there that does not need to exist if you do your estate plan correctly and safeguard it correctly. Number 5, as we already mentioned, is thinking that your will doesn't need to be probated. If your estate plan is a last will and testament, that document does absolutely nothing, helps nobody unless you have died and it has been probated within 4 years. That is the only way that a will helps you. Now, you may have beneficiaries on other things or joint owners, or things may transition other ways. But if you want to have an estate plan that does not require probate, you have to have a revocable living trust, some sort of other plan that would transition assets upon your death. There is no such thing as a will that doesn't need to be probated. A will has to be probated unless all of your other assets have been set up to transition in some other kind of way.
Yep. A will means nothing. It's simply a suggestion until it goes before the judge.
Yeah, that is misunderstood by so many people. The other thing about the will is that it does need to be probated within 4 years. So if you haven't probated it within 4 years, you also have to give notice to all those heirs at law that would otherwise have inherited if you didn't have the will. And that's a safeguard, right, to protect those people so that I'm not a bad actor and I don't bring in a copy of a will that had been destroyed, or I don't 10 years later show up with a will that maybe, wasn't real. So there are reasons for those rules that we have to comply with, but you can either make it easy for your beneficiaries, your spouse, or your kids. Just make sure that you've talked to an estate planning lawyer that does that comprehensively, does that all the time, and can help you make sure that you see the pitfalls in the plan that you have, and that you actually have that plan in place for your loved ones so that they can mourn your death, grieve, and handle what they need to handle, as opposed to being worried about how they're going to access your bank accounts, whether your will needs to be probated. All of those things can wait because you have done them a favor by putting things in place that need to be there. Anything you want to add?
Mm-mm. Happy Halloween.
Happy Halloween. See you next time.
Mm.